We've talked a lot about holding property in joint tenancy and the right of survivorship that accompanies this method. However, a matter we stress with our clients and their families is that joint tenancy is not a substitute for a proper estate plan. At most, it's a band-aid, a temporary fix of a larger yet totally avoidable problem. Hi, I'm Andrew Bethel, and as a quick refresher for joint tenancy, it's a way of holding title between two or more parties wherein the interest of the party to die first automatically, that is by operation of law, passes on to the surviving joint tenant rather than to their heirs. This method of holding title is most often used by spouses when they get married or buy property together. Based on that explanation, I'm sure the question that has come to your mind, if you already know our view on estate planning, is why would I need to put a property in trust if joint tenancy solves the problem and avoids probate at my death? Well, there are 5 big reasons that for relying solely on joint tenancy is a bad idea that we'll be covering, but they mostly build off of each other. However, as a disclaimer, while a major part of our practice is creating trust for our clients, everything I'll be discussing are problems inherent to joint tenancy itself, but that can ultimately be avoided by utilizing a trust instead. The first issue with trying to use joint tenancy as an estate plan substitute should be fairly obvious, and that is it's a temporary fix. If a married couple hold property in joint tenancy between themselves, the joint tenant titling only matters so long as both are alive and means nothing after one of them passes away. Yes, the survivor receives the interests held by the decedent co-owner at their death, but being the sole owner of a joint tenancy simply means the property is now in your name alone as if you had held title alone. Now your next thought might be to add someone else on title with you, such as a child. However, that carries its own issues. First and probably most importantly are the tax concerns. Transfers of property, even gifts, means the county assessor can reassess the property for new, higher property taxes on that transferred portion. Transfers from parents to children are exempt, as are transfers in and out of a trust, but unless you get remarried and add the new spouse on title with you, or add a grandchild on title where that intervening parent has passed away, then the county is going to reassess for higher property taxes on what was transferred. Next, there are the capital gains to worry about. If you sell property for more than you paid to acquire it, that gain may be subject to a tax, and that's between those numbers. If your spouse passes away, then their tax basis, think the amount you acquired the property to begin with, will step up to the fair market value as of their date of death, meaning your capital gains tax burden, if you sell the property, will be lessened. But that only happens at death, not on a transfer or a gift. If you add your child on title with you, then their tax basis is the same as yours, meaning your capital gains tax would be based on what you paid to acquire the property, not the value of the property when they received it, your child. There's no step up in basis. At least you may not have to worry about gift taxes though, since even though the yearly gift tax exemption level is $16,000 for 22, you also have a lifetime gift tax exclusion level equal to that of the federal estate tax level, and that's $12.06 million as of this year. And you can watch our video on the new 2022 rules on gift and estate taxes if you want some more detail there. To continue the thought of adding another on title though, adding someone on title means that you have now brought them and their troubles along with you. Of course, not to say that your children are troublesome, but having property in one's name means there's something there for creditors or lawyers to latch on to. Liens for that person's debt can now be put on the property. If the person is in, for example, a car accident and a lawsuit is then filed, well, now your property can be dragged into the mix of that suit. Fourth, we have another reason or issue that we might not typically think of, and that's simultaneous deaths. What if there's a car accident, a fire, or some other tragedy, and the co-owners are together? If you're holding title with your spouse, then the chances of you two being together most of the time is likely high. What happens if co-owners of a property in joint tenancy die at the same time? Now that answer is twofold, but to be brief, first we need to determine who died first and how far apart were the deaths, as in whether they were truly simultaneous. If one person survives the other by at least 120 hours, or 5 days, then they will be considered the survivor and thus the sole owner under the law. However, if the parties both died within that 120 hours or 5-day window, then there is no survivor at law, and thus each owner's respective estates retain the property, and their respective heirs inherit their interests in that property, effectively acting as if the property was held as tenants in common rather than joint tenancy, meaning potentially 2 probate cases in all the headaches that follow. Now this is all according to the Uniform Simultaneous Death Act. Now the final issue I want to touch on is a potential solution after a sole survivor remains, and that's a revocable transfer on death deed. Now I've already done a deep dive on these in a previous video, but these carry their own issues. They're part of the chain of title on the property itself, meaning that they are a matter of public record. Establishing one means you need to take the time to draft the deed, execute it correctly, record it with the county, and you have to do that every time you wish to change your beneficiary or your beneficiary predeceases you. And they are rigid in who you can grant property to in the first place. Now, everything I've mentioned can be overcome or outright avoided by establishing a revocable living trust. A proper trust will have safety net language for every situation I've discussed. Capital gains taxes, property taxes, gift taxes, they won't be a problem. Estate taxes can even be mitigated if the estate is over $12.06 million. Beneficiary troubles won't affect your property while it remains in trust. Simultaneous deaths will be accounted for in the trust provisions, and it won't force the property into probate. Your distribution remains private, as title will only reflect the existence of a trust, not what it actually contains. The trust will account for what-if scenarios, such as beneficiaries predeceasing you. And finally, the trust is freely amendable, changeable, and revocable by you at any point you wish. Thank you for watching. If you enjoyed the video, be sure to check out some of our other excellent videos here. But don't forget, hit the like button, subscribe, ring the bell, and tell us what you'd like for us to cover down in the comments below.